the law of contracts come into play there. I would like to call upon Ranjan, who would educate us on the position in the contract law. And also a very, very interesting question, at least to me, is what if one of your key employees who knows about the trade secret leaves and joins the competition? So over to you, Ranjan.
Thank you, Don. So I think there are a few areas which Neeraj mentioned that, why people do not go out and sort of seek protection within the four corners of, either a patent law or trademark law or copyright law. I was thinking there were a couple of other areas which one could think of as well, where they are generally, I can't, maybe I can use the word, a bit fuzzy, because you, as business, we all collect certain information in our day-to-day life, and these are then, documented in some form, and then they become sort of your know-how within the internal mechanism, and you don't think about protecting them in a certain, parameters which are defined by either the copyright law or any other law. So those become important, and you share them with your employees. And what do you do with them, when it goes away? And I think one another, off-quoted example that I can think of why people feel that the trade secret is sometimes more important for me a way to protect some certain information is the, we commonly use this example, the Coca-Cola. Coca-Cola formula was never patented, and they protected it because they just thought that, if we do a patent, it'll have a limited life, it'll come out in the open, and then it'll finish. And I think there are several other examples we can see within our Indian food industry as well, where people do not go out and actually seek protection of those formulas into a tangible this thing, because they feel that, there is a limited monopoly. This has passed to me from generations and families, so let me just maintain it, like that. So, moving further, so essentially what we're saying is that when you are protecting a trade secret, either you sign a non-disclosure agreement, or you sign or in some way with your employees, you sign a non-compete clause. Both of them in some way imposes a restraint on the trade. So clearly you are, the Section 27 of the Contract Act comes into play. And, the 27 would say that, anything which, any agreement which is in restraint of, exercising a lawful profession or a trade is null and void. The only exception which the Contract Act in Section 27 has put in is when you are actually selling a business with your goodwill. Then in such cases, you could impose those restrictions, and that is the only exception. Maybe at the time when the Contract Act was drafted, there were not that many situations that the legislature in their wisdom had imagined. But I think one of the words which I picked up in the exception, it says, and I read it there, provided, even for that exception, it uses the word provided such limits appear to the court to be reasonable. But what has happened is that this reasonable doctrine, which is built in the exception, is not still applied by our courts when they are looking at, in particular, the restraint of trade, non-compete clauses in our employment contracts, particularly. And so what happens is that the court's general thinking is that when an employee goes to seek an employment, he has a very limited bargaining power. So, and we cannot put any restraint of trade. So let's just give him that benefit of doubt under Section 27 and say that, look, you cannot, within the post-termination of his employment, you cannot seek to impose restriction which would restrict his employability in some way. And that is how most case laws have developed. But what I found interesting is that way back in 1963, there's one particular case called Ranjan Gokul Kari case, where this gentleman who was employed as a shift supervisor and trained by a company to work in a tire cord manufacturing unit, he signed a contract which said that for 5 years, you will not change your job, and you will not join a competitor. He obviously learned his job, and for a higher emoluments, he joined the competitor. The Supreme Court in this decision actually came to the rescue of the company and said that this is a perfectly good clause, a clause which we would like to, respect, because this is something which is, came within the course of the employment. So this was accepted during the, by him as a course of employment. But what is surprising is that as we move down the years, this has not been actually applied in most of the cases. If we look at the, the other case, which is the American Express case, which many of you may have sort of seen, this related to a lady who was working in the wealth department of the American Express Bank, and then she resigned, and then she decided to join a competitor bank, and American Express was of course not happy about it, and so they brought an action seeking a restraint order, and they said that, look, the information and the data related to our wealth client, because she was heading their North India wealth department, is something, which is a trade secret, and we should have the right to, restrain her from using those to the benefit of our competitor. What I found surprising in that judgment was that a very narrow view in terms of defining what could be a trade secret. So I'll read it from what the judgment says. The routine day-to-day affairs of employer, which are in the knowledge of many and are commonly known to others, cannot be called trade secrets. A trade secret can be a formula, technical know-how, or peculiar mode or method of business adopted by an employer which is unknown to others. So it's a bit narrow view on what could be a trade secret, because not everyone invent a formula, in my view, or adopt a technical know-how, because relationships these days are absolutely an important area, which many of us want to protect. The other day I read an article on what should the law firms be doing when they encourage their associates to maintain the LinkedIn accounts, and on the LinkedIn accounts they maintain thousands, hundreds of contacts from their clients, and then the next day he walks in and goes to some other competitor firm and takes away all the relationships. People would say that relationships are relationships, you can't control them, but then, there are decisions from the US, and if you look at some of even the UK courts, then those seem to go on the two doctrines, one being whether the restrictions was reasonable, which as I mentioned in 1963 case, the Supreme Court did bring in that doctrine. And then there is the US doctrine, which is a bit harsh doctrine, which I think talks about whether there is can be reasonably inferred that someone who joins a competitor carries with him the information that is valuable to the competitor. So that may, in the Indian context, somehow that may not sit that well. Now, just to sum it up, I think what I can say is that the courts are now trying to say that, look, within the course of employment, if you impose non-compete clauses, and if they are, you can show that these are necessary as a part of your job, as a part to carry on that, that information has value, then the restrictions are also reasonable, and you may be able to enforce that sort of, restriction. But in general, many more cases, and if I have time, I can keep sharing where things haven't really gone, that well in terms of the protection that was granted. Although, it's a mixed bag. Let's look at the, another case which actually went in favor of the company. This case is called a 2012 decision, where this is called Homag India Private Limited versus Ultaf Ali Khan. In this case, he signed an letter, the employee, which had the confidentiality clause, and he was, during the course of the employment, he was expected not to take employment with any of the competitor, and even it had a clause which says that if you join a competitor, direct competitor, after even resigning after 1 year, then that will be also, that was also something which he agreed. As it happens in the commercial world, the gentleman went ahead and joined the competitor. The case was brought against him to restrain him from taking that employment. The issue raised was that, look, this is, I mean, there is no privity of contract between the new employer and the case cannot lie against them. That was one question. It normally comes up in most of the trade secret or non-compete clauses agreements, that the prospective or the new employer and the current employer doesn't have any privity of contract here. It is between the ex-employee and the employer that the case should go on. But the judge, in this case, the Supreme Court, it went up till Supreme Court, this decision, and the Supreme Court said that, look, we think this may not be the right way to go about it, and let's not assume non-existence of an actionable right here. And in the circumstances that were described and the way the agreement was drafted, they upheld that this is he should not have joined the competitor. That brings me to my last case, which is a 2013 decision, and again, surprisingly, a U-turn by the courts, and that a Delhi High Court decision. And here, it is against an anchor who's joined a new television setup, and this anchor signs a 2-year agreement, and he says, and the clauses are very clear that you will not, during the course of the 2-year agreement, you will not join any competitor, you will not, go and, do any other program for anyone else, and, things like all of those things. There's also a clause in that agreement which says that in case you leave, you will have to pay the 6 months as a, fee of your contract, which is there. He, after about a few months of working, or maybe it's about 1 year of working, he expresses his intention to resign. He sends in a letter to his employer saying that I want to leave. The employer